3 of the lecture series, Federalism and the Constitution. In today's lecture, we're going to be looking at the Constitution of the United States and the amendments that have been added to this, what Thomas Jefferson called a living document. The Constitution of the United States is our federal constitution, and it is a document that comes about through the Constitutional Convention of 1787 and ultimately becomes ratified as the codified framework of law, our Constitution, in 1788 when New Hampshire becomes the 9th state, fulfilling the requirements of 9 states to ratify, defined in Article 7, the ratification clause of the Constitution of the United States. Upon the ratification of the Constitution of the United States, the document has guided our nation's missteps and our nation's progress. Because the Constitution is a living document, the Constitution, like a living organism, is capable of change. It is a document that is designed to change, to be amended, to reflect different attitudes, different cultures, and different interests of different people at different times in this country's history. Justice Kennedy of the United States Supreme Court had this to say about the living document of the Constitution of the United States in terms of what it was, who created it, and what it was intended to be. Justice Kennedy said, "They, the founders of the Constitution, knew that times can blind us to certain truths, and later generations can see that laws once thought necessary and proper, in fact, serve only to oppress. As the Constitution endures, person in every generation can invoke its principles in their own search for greater freedom." This last part to Justice Kennedy's quote, that persons in every generation can invoke its principles in their own search for greater freedom, is a product of the Constitution itself. The Constitution affirms the capacity of the people to participate through the law, to change the law, to reflect the difference of culture, the difference of people, and the different attitudes of the citizens relative to what their government can and cannot do. The Constitution, a living document. The Constitution is a constitution insofar as it fulfills the most basic criteria of a constitution. We call our federal constitution a federal constitution because embedded within the Constitution of the United States is the establishment of the principles of federalism. To review, a federal system of government is a system of government in which power is divided between a centralized government and smaller units. What we see in the Articles 1 through 7, and in the amendments of the Constitution, is an attempt to balance and to reconcile individual freedoms of individual people and individual states with a recognition for authority to be vested within a centralized government, a true constitutional balance of a federal system of government. Our federal Constitution of the United States fulfills the criteria of a definition that fully fits within an idea that a constitution should be a codified framework of law prescribing what government can and cannot do. This understanding that a constitution should prescribe not only the powers of government insofar as the Constitution prescribes what government can do, what powers the government will have, but it also must establish limitations on that governmental capacity to do things. Insofar as our Constitution not only prescribes what government can do, but also prescribes the limitations of government by restricting it from doing certain things. Our federal Constitution of the United States fulfills the most basic definition of a constitution itself. The specifics of our Constitution are that it is comprised of 7 articles, and it is these 7 articles that were approved unanimously in September of 1787 and sent out to the people to approve. Ultimately, that Constitution, the 7 articles that were approved unanimously at the convention in 1787 and ratified by the 9 states that were required for ratification, has been changed. That document has been changed 27 different times with 27 different amendments. In today's lecture, we're going to look at some of the articles that make up the original Constitution, which still are a part of the federal Constitution today, what goes into some of those different articles, and we will also talk about some of the 27 amendments. The first 3 articles of the Constitution of the United States are also known as the institutional articles. They are called the institutional articles in their comprehensibility as they are Articles 1, 2, and 3, the pieces of the Constitution that prescribe the powers and limitations of the institutions of government. Article 1, Article 2, and Article 3 define the parameters of what our Congress and our President and our courts can do. I think it's important for us to talk a little bit more specifically about Article 1, Article 2, and Article 3 relative to the different institutions of government. We will review just an overview, rather, of Article 1, 2, and 3, and later in the semester, when we get to the lectures on the Congress, and then after that, the presidency, and then finally finishing with the courts, we will look in a more in-depth way at the constitutional prescription and limitation of those 3 different institutional branches of government. An overview of Article 1 is the institutional article that prescribes the powers and limitations of the legislative branch, or the United States Congress. The first section of Article 1 prescribes that we shall have a legislative branch of government and that the United States Congress shall be divided into 2 houses. Those 2 houses are reflections of the Virginia Plan and the New Jersey Plan, insofar as the House of Representatives, the first house of Congress, seats its representatives based on populations proportional to the states. So the larger the populations within different states, the more seats that state will get in the House of Representatives. The second house within the Congress, as established within Article 1 of the Constitution, is the Senate. The Senate is a reflection of the New Jersey Plan, insofar as there is a fixed number of representatives, 2 per state, regardless of the state's population. The second establishment within Article 1 relative to the Congress is that Article 1 establishes the manner and qualifications of membership within each house. There are different qualifications that one might meet to be a member of the House of Representatives than to be a member of the Senate. Article 1 also prescribes the powers and limitations of the legislative branch. It describes in grave detail the specifics that Congress and the legislative branch, the House of Representatives and the Senate differently, can and cannot do. So Article 1, again, an overview of it, and we will return to a more in-depth understanding of Article 1 later in the semester, establishes that we will have a legislative branch of a bicameral nature, which means that it will be a 2-housed Congress, the House of Representatives and the Senate. Article 1 also establishes the manner and qualifications of the memberships within each of the houses, and it also describes the power and limitations of the legislative branch in total. Article 2 is a part of the Constitution which has gotten a lot of attention in the last 100 years, as we have seen a significant increase in powers relative to the President of the United States. Article 2 establishes that we shall have an executive branch, and within that executive branch, we shall have a single president. In Federalist 70, a required reading in this class that will come later in the semester, Alexander Hamilton spends quite a bit of time and detail explaining why our executive branch should be a single president, a single executive, as opposed to a dual housed system or a dual executive as we have in the Congress. Hamilton critiques the dual consulship, which was the executive branch in ancient Rome. Rome had two presidents, two equivalent presidents in their two consuls. And Hamilton points to the competing power that happened within the Roman consuls that ultimately Hamilton suggests contributed to the decline and fall of the Roman Republic and the rise of Julius Caesar, a single executive, and ultimately the Emperor of Rome. So again, Article 2 establishes the executive branch and the office of a single executive. It also goes further in describing the power and responsibilities of the executive or the President of the United States. But it's interesting to note that the descriptions relative to the power and responsibilities of the executive branch are significantly more vague or more ambiguous than is Article 1. Article 1 is prescribed of 10 separate sections that go in much more detail relative to the power and limitations of the Congress. Article 2 has only 4 sections, less than half the subsection attention to describing the power and responsibilities and indeed limitations of the President of the United States. This inherent ambiguity as to what the President can and cannot do has created a vacuum of space that executives have used throughout the history of the United States to expand the power of the presidency. Later in the semester, when we look at the power and limitations of the executive branch in more detail through case study analysis of the different presidents that have sat in the White House, that have sat in the executive seat, we will see clearly that the ambiguity, the vagueness within Article 2 has created space for presidents to justify under the law an expansion of the power of the presidency. Article 2 also establishes that there shall be a vice president of the United States, intended to be a mostly symbolic position within the executive branch. As I've already stated, it was not intended, the vice president, to be a competing power within the executive branch, but rather a person there as in an advising capacity to the executive, to the President of the United States, and furthermore to serve as president if something were to happen to the president, say for example, die in office, either as a result of old age or as a result of an assassination or something else. Or of course, if the president was forced to leave the presidency, it is designed the vice president's office to step into that power and take over as president of the United States. And so the establishment of the office of the president, of the vice president rather, is affirmed within Article 2 of the Constitution. Article 3 of the Constitution establishes that the United States shall have a judicial branch or federal courts. Article 3 is the most vague. It is the most ambiguous institutional article in the Constitution of the United States. Article 1, which prescribes the power and limitations of the Congress, is the most detailed. Article 2, which prescribes the power and limitations of the presidency, is vague in its own right, but Article 3 is virtually absent in the Constitution itself. Article 3 is so short in detail, you can look at it for yourself in the Constitution. Article 3 is significantly shorter than the other 2 articles of the Constitution, and as such, the federal courts have seen significant increases in their role within our federal branch of government and indeed within our federal system of government in total. Article 3 not only establishes the judicial branch, but ironically, instead of giving powers to be described in detail to the courts, it rather prescribes the power of the Congress in its relation to the courts. Article 3, in establishing the judicial branch, describes that it is the Congress that shall have the power to expand the number of courts as it sees fit. For example, the United States used to only be a country of 13 states. And as such, we didn't need as many federal courts as we do today. And as as the United States has expanded first with the Louisiana Purchase and later with the culmination of the Mexican-American War in the middle part of the 19th century, the United States has become geographically a larger place, and also as a result of its population growth, a larger populated country. And as a result of that, there is a need to have federal judicial representation in every state within the country, and we have expanded over the 200 plus years of the federal court's involvement in our federal branch of government, the number of courts from 1 to 94 federal district courts. And of course, we also have the Federal Court of Appeals, where there are 13 federal courts of appeals. And ultimately, we have one federal Supreme Court. And so throughout time, we have seen the legislative branch of government, as a result of the power it is given in Article 3 to expand the number of courts, the legislative branch has created 3 levels of federal courts: the district courts, and there are 94 separate district courts throughout the country. The second level of the federal courts is the Court of Appeals, and there are 13 courts of appeals. And then, of course, the highest level of the judicial branch is the Supreme Court, and there is only one, and the Supreme Court is in Washington, D.C., and there are 9 judges that sit in that Supreme Court. How those justices get into those seats, we will talk about later in the semester. How long those judges serve once they are in those offices and sit on those different benches within the district courts or the courts of appeals or even the Supreme Court. Again, we'll return in more detail to the judicial branch and some of the specifics within Article 3. But we also know that Article 3 establishes the office of Chief Justice, which is the highest ranking judge in the federal courts that currently sits within the Supreme Court. The Chief Justice of our federal Supreme Court is a gentleman by the name of John Roberts, Jr. He has been the Chief Justice of the United States Supreme Court since 2005, and when he was appointed Chief Justice of the Supreme Court, he became the youngest Chief Justice to ever sit in that seat. And again, it is a product of Article 3 establishing not only that we will have federal courts, a judicial branch of government, but also that within that branch we will have a Chief Justice. Later in the semester, when we get to the discussions on the federal courts, we will talk a little bit more in detail about the role and powers of the Chief Justice relative to the functioning of the federal branch of government called the judicial branch. Article 5 of the Constitution, which establishes the Amendments Clause, is a very important piece of the Constitution of the United States. So beyond the institutional articles, Articles 1 through 3, another important article to pay close attention to is Article 5. Not to suggest that Article 4, which comes, of course, in between Article 3 and 5, isn't important, but in terms of understanding why the Constitution has been given a capacity to grow and to fulfill what Jefferson called a living document. It is the Amendments Clause, or Article 5 of the Constitution, that is of the most importance to this capacity of the Constitution to do what Justice Kennedy suggested, in that the Constitution can endure and reflect the different principles that each generation of Americans would like to invoke within that codified framework of law. It is Article 5 that reads that Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of several states, shall call a convention for proposing amendments. Article 5 doesn't end there. It goes on to state how specifically that process is to play out. But it's this idea that the Congress can, through a proposal, when it deems it necessary to amend the Constitution, can do so with 2/3 of vote within both the House of Representatives and the Senate. And it also can be changed as a product of states initiating this process. So if the federal Congress in the House of Representatives and the Senate does not or cannot change the Constitution through a legislative action, the states themselves can petition the legislative branch of government through an application for a convention, which will put forth the amendments as proposed by the states. 2/3 of the states are required to put forth that application for a convention to ultimately change or amend the Constitution to reflect a shift in the people's understanding of how the Constitution should be applied. There is no question that without Article 5, the Amendments Clause, we would not have seen perhaps the most significant changes to our Constitution that came about in 10 different ways, all at the same time. Of course, I'm talking about the Bill of Rights. As we've already discussed earlier in this lecture series on federalism in the Constitution, it is the Bill of Rights that become an important addition to the Articles 1 through 7, insofar as it is the Bill of Rights that create a context to limit the central power by affirming that Congress shall make no law in some very specific ways. And furthermore, not only do the Bill of Rights in their capacity to be 10 amendments prescribe limitations on the federal government, but it also creates a context whereby states are reserved power. And finally, and perhaps most importantly, prescribes the powers that individuals shall have relative to their government. So I wanted to spend some time talking about 3 of these Bill of Rights, of these amendments within the Bill of Rights, which ultimately get amended to the Constitution on December 15th, 1791. The First Amendment, which reads that Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances, is an important amendment. The First Amendment, and more importantly, the first 5 words of this amendment. Remember, the First Amendment is significant. It is the first change that is made to the Constitution of the United States. And it's the first 5 words of the First Amendment that really create an understanding of why the amendment processes, which is protected in Article 5, is important. The first 5 words of the First Amendment read, Congress shall make no law. This is a clear limitation on the capacity of our government to write law, to create laws. The First Amendment is very clear in limiting the capacity of Congress and our federal government to establish laws that might take away a person's ability to freely practice their religion as they see fit. And of course, Congress shall make no law abridging the freedom of speech, limiting the capacity of people to speak freely, or of the media or the press to serve as a watchdog on government in terms of what government might or might not be doing necessarily to negatively affect the people. And more importantly, perhaps, is the right of the people to gather in assemblyment and petition through social movements, through vote, through protest, as to what that government is doing, to redress government relative to the grievances that the people have as to what that government is doing, is an affirming in the First Amendment of the third argument within the Declaration of Independence. The idea that the people, as prescribed in the Declaration of Independence, should have the power to alter their consent of that government is affirmed in law here in the First Amendment, when the First Amendment says that the right of the people peaceably to assemble and to petition the government for a redress of grievances is an affirming of the values established in the Declaration of Independence through law in the form of the First Amendment to the Constitution of the United States. Of course, there is much debate as to how free you are in this country to exercise your freedom of speech and whether or not certain limitations on that individual freedom of speech should be afforded to government insofar as an individual's exercising of that freedom of speech might necessarily affect the freedom of others within the country or within your community to freely exercise different capacities as individuals. For example, if a person in exercising their First Amendment right to freedom of speech necessarily creates an environment that threatens and could lead to physical threat of a person's safety, does that mean that that person's individual freedom of speech to say, yell fire in a theater and create an environment of extreme concern, which could lead to a trampling of an individual and maybe even a death? Could we justify under the law limiting to an extent individual freedom of speech? And also this capacity of people to gather in assemblyment. It is important to recognize that the people peaceably to assemble. What is peaceable assemblyment? Exactly. Much debate has gone into how exactly to understand the Constitution, specifically the First Amendment. So when it says that the people have the right to assemble, but more specifically the right of the people to peaceably assemble, is a protest that results in a physical occupation of a building, is that peaceable assemblyment. When there are protests of people gathering whereby the people are using violent language and a call for violence, is that peaceable assemblyment? These are important questions that have received significant debate throughout the years, and of course will remain a part of our government and a point of contention in our understanding of how the First Amendment should be read relative to preserving not only an individual's rights, but also the social protection of the plurality of the American people. Alongside the First Amendment and the debates that go into that particular change in the Constitution is, of course, the Second Amendment, which reads, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." The debates that have circled around the Second Amendment have come mostly within the context of what it means to bear arms, meaning, is it the right of individuals to bear arms, or is it the right of people who are members of a regulated militia to bear arms? Historically, there has been some debate as to whether or not it is an individual's right to bear arms, or whether or not an individual must be a member of a particular group in order to exercise their Second Amendment freedom to bear arms. So the debates have circled around this capacity of whether or not individuals have that right to bear arms, or whether or not you must be a member of a group of individuals to bear arms. Historically, the courts have sided with this idea that individuals have a right to bear arms, that individuals do not have to be members of necessarily a regulated militia in order to have that right of the people to keep and bear arms. And so given that it has been essentially conceded that it is an individual's right to bear arms, the question ultimately becomes, should there be a limitation on the types of arms that individuals can bear? recognizing that people can bear arms, but recognizing that maybe there should be laws restricting the types of arms that people can bear while preserving their right to bear arms. For example, much debate around gun restriction and the capacity of people to bear arms relative to fully automatic assault rifles has, of course, been the center of debate around the Second Amendment. So, an individual can bear arms insofar as they can purchase a semi automatic handgun or a semi automatic rifle, and in that way, people still have their Second Amendment rights protected, while at the same time, government regulating and restricting individuals' rights to gain access to assault weapons or weapons that are determined to be fully automatic. This capacity to restrict access to certain types of arms while at the same time protecting individuals' access to their right to bear arms is a point of enormous debate and creates ideological camps of opposition. And each state throughout the country has decided to regulate their own state laws relative to the Second Amendment preservation of preserving a person's right to bear arms differently. In California, a person who wants to exercise their right to bear arms has to go through a background check and a cooling off period, whereby a person in California who wants to exercise their Second Amendment right to bear arms as an individual can't just walk into a Walmart or a sporting goods store and purchase a gun and walk out with it that same day. That individual has to, as a result of California law, go through a background check to make sure that that person isn't a felon or a person who has had their rights restricted based upon their legal record. So a background check is done in the state of California, and then furthermore, a cooling off period of several weeks is required before the person can actually pick up their gun. The idea is that in California, the people of the state have decided that we don't want people who might have necessarily had a fight with someone going to a sporting goods store and purchasing a gun and then walking back to their neighborhood or wherever they're at and then using that gun to do greater harm to an individual. The idea behind the cooling off period is that if a person is engaged in some kind of hostile debate with someone, that if they could walk away and cool off a bit, that perhaps wiser minds would prevail and ultimately wouldn't necessarily turn to guns to exercise their contention and concern with that other individual. And so California, like many states throughout the country, requires not only a background check, but also a cooling off period before a person can exercise their Second Amendment right to bear arms. Juxtapose that with a state like Oregon, just north of California, where any individual can walk into any sporting goods store and fill out an application, pass a quick background check, and walk out with that gun in a few hours. There is no, days-long cooling off period in Oregon, and the background check of that person's history isn't as in depth as it is in the state of California. So the restrictions on an individual's rights to bear arms in California are much more liberal, much more loose than the regulations in California. So the Second Amendment is a amendment that is, of course, circled with much debate as to whether or not states should have the capacity to restrict access to certain types of arms and furthermore slow down the process of a person in their capacity to fulfill their Second Amendment right to bear arms. And again, this, like the First Amendment, is something that will endure. The debate around the Second Amendment is something that will endure beyond our generation, and of course has been a point of contention throughout the history of the Constitution of the United States. The Fourth Amendment is another significant amendment to the Constitution insofar as it reads, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The Fourth Amendment has created an important debate between liberty and security. The question of an individual's freedom to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures is, of course, an important liberty protected within the Fourth Amendment. But in the context of preserving and protecting national security, and indeed security of the country and the individuals that live within it, in the post 9/11 world, days after September 11th, debate circled around the idea that maybe the Fourth Amendment and the process established within it should be suspended to enable the government to expeditiously pursue threats to the security of the country. The argument, of course, behind the debate that went into this conversation days after 9/11, of course, culminated in the passation of the USA Patriot Act, which does create a special mechanism in so far as the FISA courts is a special court that is created to expedite the process of issuing warrants, so that the Department of Defense and the Department of Homeland Security can pursue individuals and, of course, seize property and papers and effects, of which now include digital effects, including emails and online correspondence, as well as bank records, deposit accounts, and, of course, phone call conversations. Warrants can be issued to tap phone call conversations. Warrants now can be expeditiously issued to access bank records to monitor transferring of funds. And, of course, warrants can be issued to access email dialogue between you and another individual. These warrants have always been able to be issued as a product of the Fourth Amendment. As it reads, warrants are, of course, required to be issued upon oath and affirmation, which, of course, is required. That warrant is required to describe in detail the place that's going to be searched and the person or things that will be seized. This has always been a process of the Fourth Amendment, but the USA Patriot Act first passed in 2001 and then re-amended in 2005, and then most recently amended yet again earlier this year in 2011, has given the federal government in the Department of Defense and the State Department, as well as the Department of Homeland Security, the capacity to expeditiously pursue warrants to go after individuals or groups of individuals that might necessarily threaten the security of the state. And the question of the expedition relative to the issuing of the warrants has created some concern and some debate as to whether or not there has been enough attention paid to why the warrants are being requested and exactly how unreasonable the warrants might necessarily be. And so remember, the first half of the Fourth Amendment is there to protect individuals and their properties and their papers and their effects against unreasonable searches. And of course, to prevent government from seizing that property and paper in an unreasonable way unless warrants are issued. But the question about the reasonability behind the issuing of the warrants and the expedition of those warrants being issued is, of course, a question that has been begged relative to the speed in which those warrants can now be issued to search and seize property, papers, persons, and effects, of which include emails, phone call conversations, and of course, online dialogue. And so the Fourth Amendment has created a debate that has really framed a conversation as to what do you value more and what should the country value more? An individual's freedom to be secure against unreasonable searches and seizures of their property, or the security of the country, whereby people should be able to get onto a train or onto a plane or shop in a mall without fear that their lives will be in jeopardy because the warrants that are needed to search people are tied up in courts and tied up in process, and of course are slowing down the security agencies and their capacity to get people and to gain access to effects that might necessarily harm others and threaten the security of an individual's freedom and furthermore the security of the nation. This debate between liberty versus security is not an easy debate. Obviously, everyone values their individual freedom and security, but at the same time, we also value our security from threats from other people who might want to harm us, and our safety is important. And so the question is, how do we balance this incredible tension that is created within the Fourth Amendment? How do we balance liberty and security? If we don't have to choose between liberty or security, how do we balance those two things? And if we have to balance the scale in such a way that gives perhaps more weight on the scale to liberty or security, while at the same time preserving the other, which do we value more in this choice between liberty and security? The Fourth Amendment is an amendment that has come into light in our world, as of course we in the 21st century live in a world that is of a constant changing nature, and a world in which of course threats to our individual safety and threats to our national and communities' safety are ever present. And so the question as to how to preserve that safety and that security while balancing that with the Fourth Amendment protection of rights of individuals to be secure from unreasonable searches from the government is of course a question that will frame and a debate that will come out of that framing for generations to come. The First Amendment, the Second Amendment, and the Fourth Amendment are examples of changes that have been amended within our Constitution, and those changes have not come without debate. Those changes have not come without a deep conversation throughout the nation. And of course, we will continue to see changes to our Constitution through the amendments process as it is protected within the Constitution in Article 5, which prescribes that this Constitution is indeed a living document and is capable to be changed. And so the amendments are important, and the process of amending the Constitution is an important step in giving the people the capacity throughout time to be able to reflect in law the changes within our nation. Thank you. And this lecture, part 3 in Federalism and the Constitution, concludes the lecture series, Federalism and the Constitution, the distribution of power within the federal government. Thank you.